Hello and welcome, dedicated aspirants, to our ongoing series on the Indian Constitution. Today, we're diving deep into a crucial, though often overlooked, section, Part 8, which deals with the Union Territories. For anyone preparing for the UPSC and other competitive exams, understanding the nuances of how these territories are administered is non-negotiable. Part 8, spanning from Article 239 to Article 241, lays down the entire framework for the governance of Union territories, including the unique arrangements for Delhi and Puducherry. So, grab your notebooks, and let's demystify this essential part of our constitutional structure. First things first, what exactly does Part 8 cover? In simple terms, it outlines the administrative machinery for the Union territories. Unlike states, which have their own autonomous governments, Union territories are directly administered by the Union government. Part 8 explains this fundamental relationship and also carves out special provisions for territories like Puducherry and Delhi, which have their own legislatures. It's this blend of central control and limited self-governance that makes this topic so fascinating and, frankly, so important for your exams. We will explore each article, one by one, to build a crystal clear understanding. Let's begin with the foundational article. Article 239. This article states that every Union territory shall be administered by the President, acting through an administrator appointed by him. This administrator can be designated as a lieutenant governor, a chief commissioner, or by any other name the President deems fit. The key takeaway here is that the administrator is an agent of the President, not a head of state like a governor. The President can also appoint the governor of an adjoining state as the administrator of a Union territory. When a governor functions as an administrator, they act independently of their council of ministers from the state. A landmark Supreme Court case, Satyadev Bhushari versus Padamdev, helped clarify this structure. The court ruled that Union territories are not states and that their administration falls squarely under the Union government. It emphasized that Parliament has plenary powers to legislate for Union territories on any subject. This judgment cemented the principle that, despite any local administrative setup, the ultimate authority over a Union territory rests with the center. This is a critical distinction to remember when you compare the status of states and Union territories. Now, let's move on to the special cases, starting with Article 239A. This article, inserted by the 14th Constitutional Amendment Act of 1962, empowers Parliament to create a body to function as a legislature and a council of ministers for certain Union territories. This provision was used to establish a legislative assembly and a council of ministers for This means Puducherry has a degree of self-governance, with elected representatives making laws on subjects in the state list and concurrent list. However, this power is not absolute. The case of K. Lakshminarayan versus Union of India provided important clarity on Puducherry's powers. The Supreme Court held that the Legislative Assembly of Puducherry has limited powers and that its authority is always subject to the overriding powers of Parliament. This means that if there is a conflict between a law made by the Puducherry Assembly and a law made by Parliament, the law made by Parliament will prevail. This reinforces the idea that even with a legislature, a Union territory's autonomy is circumscribed by the Union. Next up is the most discussed and debated provision in this part, Article 239A, which grants special status to the National Capital Territory of Delhi, inserted by the 69th Constitutional Amendment Act of 1991. This article provides for a legislative assembly and a council of ministers for Delhi, headed by a chief minister. It also established the office of the lieutenant governor, or LG, as the administrator. This created a unique, quasi-federal structure for the nation's capital, a model that has been a subject of constant political and legal interpretation. What makes Delhi's case particularly unique? Article 239AA specifies the legislative powers of the Delhi Assembly. The Assembly can make laws on all matters in the state list and concurrent list, except for three crucial subjects: public order, police, and land. These three subjects, often called the reserved subjects, remain under the exclusive control of the Union government, exercised through the lieutenant governor. This division of power is at the heart of the administrative and political tussles we often see in Delhi. This very issue was at the center of the landmark case, Government of NCT of Delhi versus the Union of India. In its 2018 judgment, the Supreme Court delivered a monumental verdict. It held that the Lieutenant Governor is bound by the aid and advice of the Delhi Council of Ministers on all matters except the three reserved subjects of police, public order, and land. The court clarified that while Delhi is not a full-fledged state, its elected government has a genuine say in its governance. The LG cannot act as an obstructionist, but must work harmoniously with the elected government. This judgment significantly empowered the elected government of Delhi, establishing a more collaborative and democratic framework for its administration. What happens if the constitutional machinery in Delhi breaks down? Article 239AB provides the answer. This provision is similar to Article 356 for states, but it applies specifically to Delhi. It empowers the President, on receipt of a report from the Lieutenant Governor or otherwise, to suspend the operation of Article 239AA. If the President is satisfied that a situation has arisen where the administration of the NCT cannot be carried on in accordance with Article 239AA, he can impose President's rule, taking direct control of the administration. This serves as a constitutional safety valve. Now, let's talk about the judiciary in Union territories. Article 241 gives Parliament the power to constitute a high court for a Union territory. Alternatively, Parliament can declare any existing court in a territory to be a high court for the purposes of the Constitution. For instance, Delhi has its own high court. Parliament can also extend the jurisdiction of a state's high court to a neighboring Union territory. For example, the Bombay High Court has jurisdiction over Dadra and Nagar Haveli and Daman and Diu, and the Calcutta High Court has jurisdiction over the Andaman and Nicobar Islands. A relevant judicial pronouncement on this is the case of NBG Giboy versus Assistant Collector Tana. The court affirmed that Parliament has the supreme authority to legislate on the jurisdiction of high courts with respect to Union territories. It clarified that Parliament can extend the jurisdiction of any high court to any Union territory or create a new one, as it deems fit. This highlights Parliament's ultimate control over the judicial administration of these territories, ensuring a cohesive legal framework across the country. So, why is Part 8 so indispensable for your UPSC preparation? Firstly, it's a hot topic for both prelims and mains, with questions frequently asked about the status of Delhi, the role of the Lieutenant Governor, and the legislative powers of Union territories. Secondly, it is central to understanding the federal structure of India. The relationship between the center and the Union territories, especially Delhi, is a living example of cooperative and sometimes confrontational federalism. Understanding the articles and the related Supreme Court judgments will give you the analytical depth needed to tackle complex questions on governance and polity. In conclusion, Part 8 of the Constitution, though brief, is incredibly potent. It encapsulates the principles of central control, delegated governance, and special administrative arrangements that are vital to India's unity and integrity. Mastering these concepts is not just about memorizing articles. It's about understanding the dynamic interplay of power between different levels of government. Keep studying, keep revising these key articles and court cases, and you'll be well prepared to handle any question that comes your way. All the very best for your UPSC journey. Thank you for watching, and don't forget to like, share, and subscribe for more insightful content.